Yes, ma'am, you are audible. I request the council one from MC10. Unmute yourself, sir. No, 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 you're not audible.
Am I audible now?
Ah, yes, now
Am
you
I
are
what?
audible, sir. Hmm.
Thank you. Very good evening.
Good evening, sir.
I'm Council One on behalf of petitioner. And I'm joined by Council number 2 and researcher. They are joined by from a different location, from a different
What's your
unit.
name called? MC10.
MC10,
And you will be the mooter number 1, sir. Speaker number 1.
mooter number 1, speaker number
How
1.
much how much time you will
Uh,
take?
I'll be taking 15 minutes. My Council number 2 will take roughly 10 to 12 minutes, and
And
the
how many
remaining time.
you are going to address, sir?
Repeat again.
How many issues you are going to address?
Issue number 1 and 2 I'll be doing.
And speaker 2, 15 minutes. I think
15, 10 to
it's a
12 minutes
10 to 12.
and 3 minutes for the rebuttal.
Okay.
3 to 5 minutes, whatever is the remaining time.
I think 2.5 minutes for rebuttal, I think. What I have.
Yes.
And I think this entire round will be for 35 minutes. So I don't know.
We were told the maximum is 15 minutes for one speaker.
Minutes. For speaker number 2, how much time she will take or he will take?
She needs only 10 minutes, 10 to 12 minutes.
And
What is the maximum time allowed for one speaker?
sir, that's they will. I don't know. They let you.
Yeah.
That issue number 3 and 4.
Yes.
Please proceed, sir. Let me
Um,
take your video. Let me take. Sir, your time has already been started, sir.
um, your leadership, if you're and Your Honor, if the bench is comfortable, may I please I seek your permission to address the bench together as a lordship,
As ma'am.
as ma'am. Much obliged. Uh, Ma'am, this is a very unique case related to fundamental rights of the people. As there is as the technology is progressing, there needs to be some lawful consideration for what is going to happen or what things are resulting in.
Hmm.
And beginning with what the case is about. I would like to, with your kind permission, I would like to
Sir, we'll
state
come to the
the
first.
jurisdiction.
Sir, nahi. Before that, we'll come to the very front page of your memorial. Because that was the first thing that comes to my table. Please come to the very first page of
Yeah.
the front page.
So,
The yellow.
so the yes.
Ah.
So this is the matter where Mr. Cho has filed a PIL in Supreme
What
Court.
is in the matter of Cho bracket PIL petition and Rathi and others aggrieved individual petitioners versus Rajesh Verma? These are platforms. And what does it mean, sir? What will you please explain this to me, sir? And where is the
I didn't hear the second part of the question.
Sir, will you please explain your case title to me?
Yes, yes. Much obliged. Ma'am, Mr. Cho has filed a PIL petition in Supreme Court. And prior to that,
No, you don't understand my case.
Rathi
Sir,
filed
is it
a
correct way to
petition
write
in
the
High
case
Court.
title? Sir, is it the correct way to write or mention the case title when you are before the Supreme Court? Cho has filed anything, sir. Maybe it PIL, SLP, counter affidavit, let it be anything, sir. So is it the right way to mention that he has filed PIL here, sir? Sir,
Uh,
Moro, I have another question to you. You have been representing Cho, Rathi, and others. So why
Yes.
Cho and Rathi you have been writing a different way? I know the matters have been clubbed there. I know.
The reason it is written differently because Supreme Court has decided to combine Rathi's matter, which was in a High Court, which has not come to Supreme Court.
Hmm.
Supreme Court only it was filed by Mr. Cho, and
Hmm.
Supreme Court decided to combine the matters and bring the High Court matter, which was filed in High Court,
Hmm.
which was a writ petition, and club the matters together. That is the reason I have written it to make it clear.
But this is not the right. This is not the correct way to mention it, sir. Cho filed PIL. That is not the correct way to write the PIL in the bracket.
Uh,
Now, when the Supreme Court or any of the court, it may be High Court also, if in any way they club the matters, sir, so you have to write Cho versus Rajesh Verma. Then Rathi and others versus Rajesh Verma. They would be the petitioners versus Rajesh Verma, Giza, and the other people. This is
much
the
obliged.
correct form, sir. This
Much
amounts
obliged.
to deduction of marks, sir. Because we never write like this. Cho bracket PIL petition. Very sorry about this. Sir, you have to. I mean, you must have some standard format before drafting a PIL. That is the very first impression of yours in the very first place, sir.
Uh, Sorry for that mistake.
Please keep it in mind from the next time and for the real practice also. This is not the correct form.
Sure.
And I request you
Much
that if
obliged.
you participate in any of the competitions, please have a standard format for the memorials because we have to give marks for the memorials as well because that is the writing expression which we received on our table. Please proceed, sir.
Uh, with your kind permission, may I state the jurisdiction?
Please, sir.
Uh, um, uh, this Honorable Court has the jurisdiction under Article 32 to hear the PIL.
Sir, I request you to please guide me with your page numbers of the memorials.
Page number 7.
Hmm.
Page number 7.
Yes.
So this Honorable Supreme Court has the jurisdiction under Article 32
Hmm.
uh, to hear the matter, this particular matter.
Hmm.
With your kind permission, may I
So
go
what
to
is
statement of
Article
fact?
32, sir? So what is Article 32, sir? What makes
Article
what brings you here before the Supreme Court of India under Article 32, sir?
There is a fundamental violation of right here,
Hmm.
and which gives us the remedy for any person whose fundamental rights are violated to approach the Supreme Court to seek remedy from the Supreme Court for the violation of the fundamental right. And in the given case, there is a violation of Article 21
Hmm. Only 21?
as well as 19.
Sure about this, sir?
Pardon?
Are you sure about this, sir? Article
Uh,
20 and 19?
I'm sure about Article 21. It's a privacy violation for sure.
Understood. What about Article 19, sir?
Article 19,
Sure about this, there is an infringement of Article 19.
that is the issue that was decided. The issues were made by the Honorable Supreme Court,
Hmm.
saying that there is a article because if some limits are kept on the devices,
Hmm.
will it come under because it is related to the commercial aspect? Will it come under? That is the reason I said Article 19 will come into picture here.
We'll proceed with the issue number 2 first, sir. Acha, before that, we'll go with the facts of the cases. Facts of the
Uh,
preposition in your words, sir.
since a considerable time is gone, I will state the facts in brief. Uh,
Huh?
the
No
just
problem.
the critical part of it. Um, uh, a company has decided to manufacture high-tech glasses which records uh, the which can live stream as well as the data of that live streaming is stored um, on the server, and when the live streaming is happening, when recording is happening, there is nothing on the glasses to see whether it's happening or not, and the recording can also happen automatically without the user being known, and
Hmm.
without whose recording is being happening without that person knowing. This is the crux of the matter of the where the manufacture of the glasses have happened. Now what has happened is Mr. Rajesh has recorded certain videos and uploaded on the screen and tried to monetize it. And one of the person who is affected is Rathi, age 52, and she and others have filed because without seeking the consent, her information was uploaded and it was monetized. Then Mr. Cho also came to know that the data was stored and it was used for data analysis by the company. And Mr. Cho has filed the PIL. And the Supreme Honorable Supreme Court has decided to club the matters together and put forth four issues. And out of that, two issues I'll be doing, and two issues my co-counsel will be doing.
So will you please tell me why the Supreme Court clubbed the matters?
So the issue of Joe brought it to the attention about the data being used uh, uh, by this thing, and a similar matter was happening in the High Court where there is a violation of the privacy right of the Rati. So both are interrelated matters talking about the same subject matter.
Hmm. And asking for the same relief, sir?
Asking for almost a similar
Do they
relief
have the
about.
same locus standi also, sir?
Can you repeat, please, ma'am?
Do they have the same locus standi also, sir?
Do they have the same locus
Locus standi.
standi? They yes. The answer would be yes because Joe is talking about the data being used in general.
Hmm.
He's talking about the in general violation of the rights. And Rathi, even though her personal data is done, but it's not just Rathi. Rathi is also with others, and their data is also uploaded. It's the same data being used. The question of the data being used and uploaded.
Okay, sir. We'll proceed, sir. We'll proceed with the issue number two first.
Issue number two. So whether imposing such restriction on devices violates Article
Number
19.1.
two. Is it issue number two?
Yes. Issue
Sir, the,
number one is
with the
continuous and
with the memorial, sir. With the page number of your memorial.
page number. Okay.
Your page number is 15, sir.
Yeah.
Issue number two.
Uh, okay. Page number 15. Whether imposing such restriction on devices violates Article 19.1. So so will it be a reasonable because Article 19.1a allows for reasonable restriction.
Hmm.
Now, this data here we have got about reasonableness. We have about the loss of the privacy, dignity, or unchecked commercial expression, and then we have the obligation of the state, uh, and then we have to balance about the balancing issue. So, most important point
Balancing
here to
issue, sir.
go ahead, please.
What is balancing issue? I request the court master to please guide us with the time also. 15 minutes with sir. So what is balancing issue?
No,
We have just mentioned the balancing issue.
so now, uh, see, what I would like to say on the balancing issue is there is a breach of privacy by using innovation, and the innovation, though we are allowing it, but there needs to be certain reasonable restriction where the rights of the personal life or personal data is not cannot be used without proper control.
But I think so. In the present matter, when you say that, but I think so. The technology which is being used here, that should not be blamed. The consumer to be take care of it. How he is using the technology. When he was buying the glasses, he is very much aware that the glasses by default have this system of device of chip and anything in it is The camera, which by default comes to the access of the internet and started recording, irrespective of anything, irrespective of any switch on and off button. But I think that has been technology. We are moving towards AI. We are moving towards the technology.
So the matter here is, can the technology be allowed to such an extent that the privacy of the individual or the data is being used without his consent?
Hmm.
That is the one issue. Second thing, can it be used for monetization without being asking him, without being informing him? Even though the glasses are there, but the person with whose audio is or video is recorded, that person may not be aware of it. Now, if somebody walks it with those glasses, maybe in a dance club or something, maybe record something. That may not be, I know the person may not be happy with what is getting recorded and being monetized on that basis.
Hmm.
So
So
there
what you
has
are
to be some.
challenging? You are challenging the technology or the monetization of the technology?
I am challenging the way the system is working. There has to be some rules and regulation. At least there should be some blinking button. There should be some guidelines needs to be made so that the person at least comes to know that certain things are happening where the certain things can be allowed to record it, and
Hmm.
certain places where it should not be recorded, where it should not be allowed. Such devices should not be allowed.
Hmm. Okay.
So there has to be some guidelines. It's not like you know anybody is allowed to come up with certain new devices or that technology advanced it to such a level that it records everything. For just for an example, right now most of us are users. If we come to if we talk about we want to buy certain products, after some days you will find the
Okay.
advertisements of those products. So your communication is directly used for monetization,
Hmm.
and it is recorded without your consent, and you are getting only limited options. You will be definitely the consumer who is does not know all the option will definitely go for those selective options, which are based again based on the monetization. So somebody is making advantages of your data without your knowledge.
Hmm.
That is not correct. There has to be some guidelines. Now
When I
when it,
was wearing the glasses, when I purchased, for example, I have been the consumer of the glasses. I have been availing the services of those glasses as well. I bought it, and somehow I was wearing the glasses, and somehow I was on the street somewhere, and somehow I came into contact with the Wi-Fi and everything that linked to the storage system and with connected to the cloud. And I did not know this. I had no intention. There was no intent of mind of recording anyone. When I was wearing it, I did not know it started because there is no on and off button. Even myself, I did not know. Let it be in this way. The person who have been using these glasses, let it be in that hypothetical situation. They did not themselves aware about this. That the glass started with the recording.
that is the one of the problem I said in the beginning of the facts itself. The person without his knowledge, the recording can start. Who is
Huh.
getting the benefit? Who is getting the benefit of it? It is the person who the server where the data is getting.
Hmm.
So even the person not being aware of the person who is wearing it, the recording can begin, and
Hmm.
still the data will be used.
Hmm.
Where these things does not cover under. Now I was looking at the memorial of our respondent. They are saying the remedy is there in DPDP Act and IT Act.
Hmm.
That part is not get covered. We need certain guidelines. Here the data is getting recorded even the without knowledge of the
Guidelines.
person.
You want us to pass the guidelines or to frame the guidelines regarding the use of the glasses, or for the prohibition of the glasses, or
I'm not talking about prohibition for sure. We do not want to restrict the innovation completely, but
hmm,
when things can work, there has to be some guidelines. There has to be a consent should be given to the consumer when he can put it on and off. It should not happen automatically without his knowledge.
hmm,
Otherwise, he will get blamed. Under IT Act, if certain privacy 66E, if he records certain thing by mistake, he will get blamed under 67E privacy violation
hmm.
for no fault of it. So there has to be some guidelines on the manufacturer itself, that there has to be some logic where this person is recording with his consciousness, yes or no, whether he wants to record or not record. Second thing, how the data needs to go, how the data will be processed.
Hmm.
There has to be some kind of guidelines
That needs to be taken. Yes, yes.
that
Now
needs to be
I
taken care.
that needs appreciated, sir. That needs to be taken care.
Can
There is a
can I know
technical
how
problem.
much time is remaining
I
so I
don't
can?
know. I even myself don't know.
Uh,
I think we'll proceed with the issue number first.
issue number one. Uh, so 5 minutes remaining. So 5 minutes remaining for council number one. Okay. So whether continuous and unrestricted recording uh, negates the privacy claim and violates Article 21. So here in my last two examples, what I gave, that also comes into this picture. Here
Mm,
there is a continuous and unrestricted recording where even the person will not know at all. So
mm,
the privacy of that person, irrespective of what is, where the person is, certain things will get recorded,
mm.
and that is the violation of Article 21, where the privacy of the person is getting recorded. So all we are seeking is there has to be some kind of guidelines to the manufacturer, some kind of guidelines how things has to
But
work,
but let it be hypothetical situation. For example, I am wearing those glasses and something a danger or a terrorist act or something act had taken place, and that the same has been recorded by my glasses, and then it will be used as a primary evidence in the court. For example, there was some terrorist attack. For example, might be, huh? Let it be a parliament attack, and my camera recorded the entire doing the entire act. Or I have, or on the roads, my camera or my phone captured the any incident which is against the woman, any incident of a child abuse. So that evidence, that recording will be used as a primary evidence in the court
uh,
against the culprit, sir. So do you think that is not amount to breach of privacy of any of the individual, but it will be result as a fruitful evidence for the court that
now
will the court to reach to the culprits and get it punished or put it behind the bar. That is not
now
a breach of privacy, sir.
So those things will happen in a public arena or
Yes, sir.
limited places. It's not like you are and the other thing is the data, how the data is getting transferred and under whose hand that crucial evidence is going,
Mm.
and where the data is getting stored, and how it is getting
Data is
getting
getting
processed.
stored with the Giza on
Yeah,
their
it is in
processor, I
on
think.
their server. So
Mm.
who is processing it?
Mm.
AI is working. They're using for AI analysis, data analysis.
Mm.
So those are the things that there has to be some thoughtfulness, some guidelines, something that needs to come out. If we let it go, then it's going to result in long term
Sir, I
violations.
think on the second issue, you are going on the right track when you are asking to framing the guidelines regarding the technology, how to use it, where the data is going, and everything. But when on the second note, when it is a breach of, I request the court master to please guide us with the time. But in the second place, when I see it, and I do understand there is a breach of privacy of an individual in the country, but I also take it in the another view. Anything wrong happened that has been used as an evidence. That would be same goes with the CCTV camera footages. Same goes with the people are doing immense amount of vlogging these days. Same goes with some random videos as well. People are shooting for their own fun, but something danger which has been covered by them. So I think that is not amount of breach of trust. If you're able to satisfy the court on this ground.
Can you just repeat the question, please? In between, I lost the connection.
Ha, absolutely, sir. Sir, you were saying the recording of the recording of the people on the streets and anywhere that is amount to the breach of privacy. That which you think that is fall under the ambit of Article 20, which is itself it is not an absolute article. However, I am saying on the other side, I am saying I look it into the different perspective as well. Anything wrong happen on the grounds that has been covered by the camera, that has been captured by the camera. Same goes with the CCTV cameras as well. The footages have been used as an evidence. Same goes with the anyone who is shooting any camera and vlogging. I don't think so that is breach to privacy.
Okay, so here
So you have
the
30 seconds.
how many seconds?
30 seconds to satisfy
Yeah,
the court.
yeah, yeah.
Otherwise,
So
we'll.
much obliged. So here the issue is, do we want to give that data to be used for monetization?
Sir, nahi, my question is not for the monetization. My question is strict to the issue. That is the breach of Article 21, the violation of Article 21, and that is why you are in the Article 32 before us.
So the guidelines can include where it can be used, where it cannot be used. So if it is a public places, certain places where you want to use, where the things are likely to happen, or maybe consider cases of where there are certain requirements for specific reasons. So that can be included in the guidelines as well.
Okay. Let's.
If,
Achha,
if the
ultimately, you want the court to frame the guidelines regarding the use of the technology and the camera and the usage of camera. Okay. Thank you, sir. We'll proceed with the voter number 2, please.
The council seeks permission to approach the bench.
Please.
The council seeks permission to begin with issue number 3.
Number 4.
Number 4,
Yeah.
the issue number 4, which is on page 20 of our memorial, is that whether Giza platform inclusive can be held liable under horizontal application of fundamental rights. The counsel for the petitioners humbly submit that Giza platforms was the manufacturer of the glasses, which seriously infringed the privacy of the citizens, and therefore it should be made horizontally liable for the violation of fundamental rights. Ma'am, before beginning, I would like to give the definition of what is horizontal application of fundamental rights. It implies that private individuals and entities like corporations, private employers, and other state non-state actors can also be held accountable for violating someone's fundamental rights. In this framework, the constitutional rights are made not only limited to protecting individuals from the state, but also from the powerful non-state entities. In the Indusland Constitution, the horizontal application of fundamental rights can be seen from various articles, such as Article 15, Clause 2, where prohibition of discrimination by private individuals is clearly stated. Next is Article 17, where untouchability is abolished, and it prohibits untouchability in any form, and it applies to both private as well as state. Next comes Article 23, where prohibition of human trafficking and forced labor, and which applies clearly to the non-state actors as well. So, ma'am, there is no direct consequence which we can draw towards Article 21, but we can see that in various cases, fundamental rights have been horizontally applied, such as in the Consumer Education Research Center versus Union of India. The Supreme Court held that Article 21 not only includes the right to health of employees, but it also applies against private employers in the context of occupational hazards caused by asbestos industries. Then coming to the case of Parmanand Katara versus Union of India, it was held that under Article 21, right to life, which is guaranteed, under this immediate treatment must be given in emergency cases, even in private hospitals. So Article 21 should not be denied even by private hospitals. Then coming to Babulal Parathe versus State of Maharashtra, in this case it was held that private hospitals cannot discriminate based on caste,
Um,
and
please. I just want to. I'm really sorry to interrupting you.
also,
Mom,
yes.
issue number 4 in your words, in a very simple language, that the bench can understand. And you are in a very, your pace is, you are in a very, very hurry. I don't want that to be. If you want
Ma'am,
time, I'll grant you the 30 seconds, 60 seconds. But just
yes,
have a patience, relax, and try to impart what you have gained. Because I know this is Moot competition. You people must have been working from last 2, 3 months to get it done and to appear before the competition. But don't be in hurry, and because I don't want you to be in hurry.
apologies, Your Lordship.
And they don't be apologies because we are a law students. It's every day is a learning day for us. So first of all, just relax, calm, and second, which is very important, whatever you want to impart in a very right form, not in that form that creates confusion, ma'am. Again, we'll come to the issue number 4. Issue number 4 in your words, in brief.
Okay. Your Lordship, can I start again?
Start again, but not with the same pace.
Yes, Your Lordship. Your Lordship, the issue number 4 is whether Giza platforms inclusive can be made horizontally liable under the fundamental rights. So basically, horizontal application of fundamental rights.
Ma'am, which fundamental rights you have been talking here?
Ma'am, predominantly Article 21, right to
Predominantly
privacy.
Article
Yes.
21. Please proceed.
Ma'am, under Articles 15,
Other
17,
other fundamental rights. That's Article. Just a second. Please proceed, ma'am.
Article 15, 17, 23, and 24 clearly make private entities liable for their violation along with the state, which have been mentioned. But there is no clear.
This, through, through this, you have been trying to make Giza as one of the parties here who is
Yes,
entitled
yes,
to the breaching of the or the violation of the
yes,
fundamental right.
yes.
Make it more expressly, ma'am. I think
Yes, Your Lordship.
what I said it now. This is the right way that I've been telling you.
Yes, Your Lordship. I can cite various cases in which for the violation of Article 21, the private entities were also made liable. Shall I cite?
Hmm.
Okay. The first case is consumer education.
Why I have read it. Proceed with your arguments. I want to
Okay.
hear you.
In the present case, Your Lordship, Giza was a public entity,
Hmm.
private entity, sorry. Giza was a private entity, and the private entity should be made liable because it has clearly infringed the right to privacy of the citizens of Indusland. The public of Indusland are affected.
The very first line you have mentioned it in the ma'am page number 22, para
Yes,
number 4.2. Giza platform is a private identity. In the
yes,
present matter, the Giza platform is a third party data processor. How it is
yes.
third party data processor, ma'am?
Ma'am, in the petition which is filed by Chow, his contention is that what the Giza platform is taking its data and it is using it for data analytics and AI training. That's why we are saying it is third
And
party
who
data.
are the other two parties in the matter, ma'am? If Giza is
Other
the
two
third
parties.
party, who are the two other parties, ma'am?
Other no, third party processor is the person who is getting the data. It is not
Nee,
any
I
other.
understand.
Yes,
Nee, that's I understand. When you say it's a third party data processor, it means the one is consuming it, the one is
yes.
recording it,
And the other person is receiving.
serving it. Yes. So the first party in the matter is the consumer.
Yes, the second is the receiver, and then comes the third
And
party,
then
which happens
yes.
in WhatsApp, our
Hmm.
everyday in our everyday conversations.
So WhatsApp is the third party data processor because
Yes,
they are taking the entire storage or the entire data charts and everything is in the WhatsApp with the WhatsApp.
yes. So
Understood?
in the present case, Giza platform is a third-party data processor, and the right to privacy, which is falling under Article 21, can therefore be horizontally applied. The third-party data processors must give a clear notice to the individuals, revealing its identity to the data processors and that how the data will be used. The social media platforms or third-party processors are to be made obliged to identify the purpose for which they would collect the data and they would use. As we can see in our day-to-day lives, as we scroll through Instagram, whatever we scroll, we get the similar feed.
Hmm.
But that does not violate privacy as such because it is just helping your feed. In the present case, Your Lordship, while Chow's data was used for AI training, it was used for the benefit of the company. So this there has been a serious infringement of Article 21.
Hmm. But the one who purchased it has the knowledge about it. Okay, whatever the camera, the glasses will capture, that will immediately go into the storage of the Giza. That was,
Yes,
I think, the consumer who is consuming the services of Giza, they already know about the.
Your Lordship, but its
Hmm.
use for data training and AI training and data analytics was not mentioned anywhere.
It
And
was not.
sufficient notice should be given to the consumers before using the data.
It means the data which have been stored to the Giza that will be automatically used by the Giza for the AI training.
Yes, AI
It
training
was
and data.
of the consumer.
Uh, Repeat, ma'am.
The data which has been stored by the Giza through their consumer that will be automatically used for their AI training or what?
AI training and data analytics.
Data analytics. Obviously. Chalo, let's proceed. Mom, please
Ma'am,
guide us with the. the court
Ma'am, how
master.
much time is left?
I how would I know, yaar? I have a stopwatch with me? I don't know.
Ma'am,
0 minute. What I know, yaar. Chalo, last 1 minute for issue number
prayer.
3.
Ma'am, prayer. Should I go to prayer?
Ma'am, issue number 3 is left.
Okay.
This is part of your syllabus. You can't skip it. I'm giving you next 1 minute for it.
Yes, yes.
1 minute
Lord,
for your issue number. I request the
your,
court master to please set the time for 1 minute. 1 minute for issue number 3 and prayer. Do you have a researcher with you?
yes, Your Lordship, we have a researcher.
Will
Yes.
start with the issue number 1.
Issue number 3, right?
Issue number 3. Sorry.
Yes. The issue number 3 is whether by providing scope for technological innovations to override fundamental rights, the states are failing to establish positive constitutional obligations. Here, positive constitutional obligations are duties which are requiring government and public entities to actively take measures to secure the fundamental rights rather than just to refrain from violating them. They compel certain positive actions for the betterment of the society rather than just staying and not violating fundamental rights. So my next sub issue is that innovation cannot override fundamental rights. The Republic of Indusland has witnessed rapid penetration with increasing technological growth, and also it has several enactments such as the IT Act and the DPTP Act, which are in place. So, but these acts have no provisions for uh, data storage, AI inputs, live streaming. These are some issues which are deeply contested, and there are legal questions in this framework which are not answered yet. So there is no proper legal framework which is in place right now for the issues such as AI.
Time up. Last 10 seconds for the prayer by the researcher.
Researcher. Ma'am, is the
And
researcher allowed to speak?
please go ahead. The one who actually prepared the memorials. Sir, you are not going to read it from your memorial. You just tell me what you are seeking from the court. What prayer you want from the court.
Yes. So, ma'am, the reliefs, our prayer is therefore in light of the facts presented, issues raised, advanced and authorities cited. Uh, the relief which we seek are as follows, which are in five folds. So, first, declare that the
Sir, don't
continuous and
repeat. That
unrestricted
is something.
recording.
Sir, don't repeat it. It is already in your
Okay.
memorial in your
So,
words.
we want the data which has been stored, where that shall be deleted. Secondly, we want the guidelines to be framed in such a way that the devices are installed with indicators such that the other person whose information is taken and knows, at least has a knowledge that information is about to be taken by the person who records it or who is wearing the glass. So, firstly, delete the recorded and stored data which is without consent. Secondly, frame guidelines, and we seek for guidelines. And thirdly, allow technological innovations. However, they shall not override fundamental rights. That is mainly right to privacy is concerned. Later on, hold Giza platforms Inc. liable such that it has used the stored data by without giving knowledge to the person whose data has been stored. So they shall be made liable for trespassing the information or by taking the information without the consent of the person whose information is taken. So that's it, and therefore horizontal application shall be applied here to the private actor. And yes, and restriction shall be issued along with the guidelines to use such devices.
That should be
Yeah,
your
that's
first
the
prayer. Instead of going the whenever the court asks you what prayer you are seeking from us. So always mention the topmost prayer of yours. what you won't
And
that, but
allow this petition.
allow this petition will be the later one. But first, you want the guidelines from the court for whom you have been representing the case.
Yes.
And so first we'll come with the guidelines, and last we'll go with the allowing the petition on merits.
Okay. Okay.
We'll proceed with the next team, please. The respondent side.
Ma'am, respondent side, speaker 1 will
Speaker
be handling
team. What is the
team
team code, sir?
17. Team 17.
Your speaker number one, sir.
Yes, ma'am.
How much time you will take, sir?
14 minutes. Speaker 2 will be taking remaining 13 minutes, and the rest time will be reserved for rebuttals.
And how many issues we are going to address?
I'm addressing issue 1 and 2, and my co-counsel will be handling issue 3 and 4.
Okay.
Ma'am, as you are aware about the facts of the case, the counsel
Just,
move on to the issues.
just a second. Just a second. I'll take out your memorial. Just a second. So we'll start with the speaker number two first.
Speaker number
Two.
2.
Yes. Speaker number two, please unmute yourself and advance the arguments on issue number four. Speaker number two. Am I audible to speaker number two? Sir, unmute yourself. I request the speaker number one to mute yourself. Speaker number two, issue number four, sir.
Speaker number 2, you are not audible.
He's still, I think.
Ma'am, am I audible now?
You are not audible, yes.
Yes.
We have a lot of background noises, I think.
Ma'am, am I audible?
Speaker number one, please mute yourself, sir. Sir, you have 30 minutes. You're wasting your time, sir.
Ma'am, am I audible?
You're audible. But why there is a lot of background noises?
I'm sorry about it.
Are you?
Can I? Hello.
I think ma'am has left. Wait. Speaker number 2, you can mute yourself.
Ma'am.
Speaker number 2, you can speak louder. Maybe it will be helpful. Hello. Speaker number 2.
I'm sorry, but am I audible now?
Yes, yes. Proceed. Speak to mute yourself. Yes, ma'am. Ma'am, unmute yourself.
Do we have any background noises?
No, ma'am.
I don't know. I can feel it. Okay, let's proceed. Let's start
So,
with
ma'am,
you.
the council would like to approach the bench
Please.
collectively. So, the issue 4 is about whether the GESA platform can be held liable under the horizontal application of the fundamental rights. So, we submit here before the court that the first that the GESA platform cannot be held liable under the horizontal application of the fundamental, as there is the
Speaker number
aspect of
two, will you please? Speaker number two, will you please mute yourself for a while? Okay, please. Please unmute yourself. I don't know why there is a lot of noise. Okay.
So, Your Lordship, the Constitution text is clearly in the Part 3 of the Constitution, and the Article 32 enforces the mechanism applies to the state as defined in Article 12. The Article 12 includes the government of the state government, other authorities within the territories of India or under the control of government of India. The GESA Platform Incorporation is a private foreign corporation incorporated in the United States of Eldoria. It does not, by any responsible interpretation of Article 12, constitute the state. It is not government funded. It is not government controlled. It does not perform the functions traditionally reserved for the government. It is a private corporation that sells consumers electronics. In case PD uh, Samdashani versus Central Bank of India, this court held that the Constitution does not, in turn, confer any fundamental rights against a private party. Such rights are available only against the state. If a private person infringes the right of another, the remedy is under the ordinary law, not under the Constitution. This is an view where the plain text of the Constitution reaffirmed in numerous decisions. To move on to the next point, the public function test is
Sir,
not
you
satisfied.
didn't mention. Sir, you did not mention your page number. You are not taking help of your memorial. You are just. You're such a. And there is a lot of noise. I think from your end. I don't understand this also. And why are you not taking help of the memorial? Writing with the page number, on which page number I have to go to the issue number 4. I don't know what you are doing.
Sorry, my lordship, I'm going through my arguments which I have prepared over there.
I know you have already prepared with your argument, sir. But this memorial and you both are new for me.
I plead ignorance.
And sir, why there is a lot of why your connections are not fine on your part when you know it's a virtual moot court competition?
Yes, my lordship, but Ma'am,
Yes.
what should I do?
Mm.
Actually, this is a busy time where I'm in these roads. Actually, I can't do anything because our college is already closed. I can't go there also. So I beg pardon on this.
From which device are you attending this?
I'm
Laptop or
using my, yeah, laptop. I'm using my laptop.
so please, I think you should put out your earphones. You
The
can
thing
talk
is,
while from speakers, no?
if I put out my earphones, it will be even more worse because there I'm near this roadside. Actually, I'm in my place where it's near the roadside, so it'll be even more worse.
Okay. Okay.
And
Mute
this is the
yourself. I
time
will
where
ask. I will ask my seniors. Wait.
can I have a word with my co-counsel over here?
Yeah, yeah.
Uh, counsel,
Speaker to mute yourself and then type in message because you are not audible. There is so much noise. Ma'am, unmute yourself. You are not audible.
मतलब आई थिंक इनके पार्ट पे इतना नॉइज है कि मुझे लग रहा है मेरे लैपटॉप में कुछ
नो मैम,
नॉइज
आपकी साइड से कोई दिक्कत नहीं है.
नहीं, बिकॉज मेरे पार्ट पे मेरे लैपटॉप से कुछ नॉइज आना शुरू हो गई है। आई डोंट नो
Oh,
क्या दिक्कत है। दैट इज आई वोंट बी एबल टू हियर हिम क्लियरली। विल प्रोसीड विद द स्पीकर नंबर 2, स्पीकर नंबर 1।
Am I audible, ma'am?
हम्म।
Speaker number one will be handling issue 1 and 2, referring to page 10 of my memorial. It pertains to first issue whether continuous and unrestricted recording negates privacy claims and violates Article 21. Your Lordship,
हम्म।
the the petitioner selectively
बोलिए सर।
am I audible now? Hello?
वेरी मच ऑडिबल, आप प्लीज।
Yeah, yeah. So over here we submit where ignoring the nuanced framework, your leadership, here privacy is not automatically lost in public places, but the court also held in the particular instance where the legitimate expectation of privacy varies according to different contexts. Now, here a person in a cafe, for example, that has uh, put in the fact sheet itself, is in a public forum where is observable to others. Now, this is not a forfeiture of dignity where he is being recorded in a particular instance. Now, the privacy is not a binary of or and off switch in a particular spectrum where reading lead to the results. If privacy expectations are identical in every location, then recording in a public place would be constantly problematic, as a recording in a hospital or a education institution would cause such problems. Now, photographing a political rally, for instance, would require same scrutiny as photographing a private gathering. Now, this cannot be equated in the same instance. Now, to apply the second prong, being reasonable expectation test, where the Puttaswamy case have propounded three prong test. to identify privacy has been violated. Now, if that includes legitimacy, legal aim, and the state's action. Now, the conversation is a reasonable person understands this, that there has been recording in a public place, while the recording using glasses has not been available to all. But over here, uh, the vital democratic function served to record in public places is incident in propagated to every cases where recording instances must be protected. Now, the conduct of officers during the altercation, in particular instance having that case of Gillick versus Cunniff, that is a foreign case where their police officers protect the person in public places. While this is not binding, this represents a persuasive consensus on the importance of public recording. Now, as a similar instance which happened in the particular case where Rati had an altercation in the road, and that particular police officer was inquiring him about the particular instance. Now, the issue of speeding was questioned as referring to fact. Para 8 of the fact sheet, where police questions Rati about the particular case where he was recording. Now, here,
Can you please advance the
the
submissions in the
public place,
particular
there
issue
where,
in your words? In your words,
yeah, pertaining to issue
what
itself
your
here. Yeah,
understanding?
in my words only.
What is your understanding regarding the issue? How do you see this issue?
Yeah, to as a person in a public forum, if I were to use these glasses and drive myself, and uh, would be in the place of Rati, would see this as a legitimate use of the particular device, as this is a major tool that could help me from escaping from any liability which I have not done as an act. So, for example, if I'm not overspeeding and the police officer would stop me and scrutinize me as not following the rules and regulation, I would be in a place where I could
Sir, but what are the rules and regulations for using this
prove
camera,
myself
this
to
glasses? What are the rules and you are
not
saying they are there?
violating any,
Sir, what are
as
the rules and
to
regulations
read it,
of using?
to add to the aspect, there are IT acts and DP. The DPDP Act, I'm talking about the traffic rules in the particular instance, but applying DPDP Act and IT rules in that particular instance
Sir, you
also.
are saying there must
Now,
be some rules and
there
regulations to
is
be
a
followed.
consensus where there is data fiduciary, there is data principle, and there are already rules and regulations in place that would protect both consumers and users as per DPDP Act and IT Act. And there need not be instances of regulation by the Supreme Court in the matter where uh, the particular aspect of recording to be violated. Now, here, the mere aspect of recording in the public forum would be portrayed as a manner where he is earning his livelihood, and he is not, as per say, violating anyone's privacy, because he is not, the video which was recorded was not posted by him but others who are involved in that accident, who are in the crowd. So here, if we look at the perspective of the situation, the aspect of utilization of gazer glasses would be a positive outcome, rather than scrutinizing the negative aspect of how the data could be misused. Now, here the aspect of consent would be crucial. Now, there in a while recording using AI glasses, that is meant as per the Giza Glasses Corporation have released this particular product. These allow users or consumers to record uh, record videos and post them online. Now, here the onus of using the data falls on the consumer, where he has used it to ensure that
But then
he
what
has
will be the
earned his living.
responsibility of
And
sir, what will be
pardon
the
your lordship.
responsibility of the state? What will be the responsibility of the state in these matters?
Okay, the state in this matters are
You have
already
you have
have
been
passed.
blaming Giza. You have been blaming Giza. You have been blaming glasses. You have been blaming consumer. Then what is your responsibility, sir, being the state?
The state have already passed DPDP Act and the IT Act, which have laid down specific rules that pertains to the data processing and the data fiduciary responsibilities. Now
Hmm.
here, if you look at how the data is being transmitted, the data fiduciary initially gets the data, and then the data is transferred, and there is a proper channel of authentic data that is
Sir,
regulated
when you say,
as
when
wow.
we sorry, when we see that these kind of video recordings have been uploaded for the purpose of monetization, don't you think there is a lack of employment opportunity in your state? That is why people are towards uploading the recording for the purpose of monetization. If people have proper
Uh,
employment, if they have proper opportunity by the government, why would they use any recordings and upload it for the money? Don't you think that people are doing for the sake of money,
monetization
their pockets?
not no
Sir,
to
understood
much
this.
obliged,
What I'm
Mediation.
trying to
Over
ask
here,
you, what I'm trying to ask from you, sir, is this: when a person wearing some glasses, data captured, uploaded it, published it in the world for the purpose of money, why the people of your state have been compelled to do this kind of a work? Don't you have the proper
over
employment
here it's not
opportunity? It can be seen in this way
uh,
also, sir.
answering your perspective, ma'am. Over here, it's Rati being a vlogger is his passion, and he wants to follow his livelihood in a manner where he also living through video
For
blogging. So it's a particular
bloggers,
skill set he
state,
uses to
state has
earn
any
his living.
laws state has any bylaws or something like this for the bloggers, or they are just switch on their camera and record anything and upload anything? Other states are taking
No,
care of these kind of vloggers, what they have been vlogging, what they have been recording, what they have been uploading?
okay, ma'am, to answer this, there are certain areas or restriction regions where you are not allowed to record. For example, defense area, you are never allowed to record or even enter into the particular area. Now, here, the state has been keeping a willful
Ma'am,
eye on misuse.
how much time we left with for the speaker number one? 14
Oh,
minutes.
wait, man, wait, wait. Um, Ma'am, we have 5 minutes.
Sir, I'm giving you last 1 minute, 4 minutes for the speaker number two. Last 1 minute, sir. 1 minute, issue
Uh,
number two. We still on
can
issue
I
number one.
okay? Can I move to issue number two, or can I answer your question, ma'am?
To issue number two.
Okay, ma'am. Moving to issue number two, pertaining to device restrictions that constitute impermissible prior restraint. Now, here, if this, as a petitioner would claim, that regulating or issuing guidelines by the honorable court would
What is the
restrain
reason?
the particular device to be used. Pardon? Pardon, ma'am?
Nothing. I was just asking the page number.
Oh, page number is 1 second, ma'am.
12. Please proceed.
12, yeah, 12. Okay, proceeding with the arguments. Uh,
Last 1 minute, sir. You have only 1 minute. Four
yeah, yeah.
minutes
So,
for your
okay.
answer.
Quoting the case of Indian Express newspaper versus Union of India, where the court held that restrictions that prevent expression before it occurs are the most serious infringement of Article 32, while restrictions that prevent expression are the most serious and the least tolerable infringement of fundamental rights. Now, moving to the next prong, being the practical effect of practical chilling effect, where, for example, the the documentary filmmaker capturing authentic public behavior, a citizen witnessing police misconduct, as a journalist capturing public reaction. All these are legitimate aims that could be hindered if there is blanket ban on restriction of using such single versus Union of India. The court applied the overbreadth doctrine to strike down a provision while targeting a legitimate harm. Now, the requirement of recording indicators applies to every user of smart glasses, and any person using that particular device in order to address a specific harm uses as
Time up.
done as
Time up.
here. The constitutional doctrine requires the regulation.
What
Shall I
now?
can I conclude this argument, ma'am? Just 30 seconds.
No, no, I'm already having a lot of technical issues on your part. I request the issue number. I request speaker number two.
No, no.
Speaker number two with your issue, sir. We couldn't able to hear you. Mama, I'll disqualify the speaker number two for their this technical glitch. They have to be prepared with their Wi-Fi connections.
Okay, ma'am. Yeah, yeah.
I don't appreciate this. When you know this is a virtual moot court competition, you have to be very
Speaker
careful with
two,
the Wi-Fi
mute
connection.
yourself.
Uh,
Ma'am, am I audible now?
no,
No, no, no. Mute yourself now.
this is not acceptable. We just have 1 hour in our hands.
Yes, ma'am. Yes, ma'am. I understand.
Let's haywire with this. Acha, but do we have any rebuttal and sir rebuttal?
Yes, I seek your permission to do the rebuttal.
Please.
Thank you. All my colleague has spoken is where it can be used. There is nothing said about even the consumer itself will not know how when the data recording will start. That is the major issue here. There should be at least some kind of blinking light, or there's some kind of guidelines where something has to be known. The person should know the data is being recorded. And I'm backing up with a case law, Shavendra Malik versus Indranil Malik case, where the consent was not obtained, the data was recorded. And I humbly request to the Honorable Court to issue some guidelines where at least the person, the consumer will know the data recording is going to start. Plus,
Okay.
some kind of
Understood. Sir, understood. Speaker number 1 or 2, do you have any sir rebuttal for the same? You must have, but you don't have the proper connections.
Yes, ma'am.
Uh,
Am I audible?
no, sir, you are not. For next
Ma'am,
5 seconds, if
sir,
you're not
rebuttals for
available,
the Learn Council. Hello,
uh,
can I hear?
please,
Yeah, am
please.
I audible right now? Yeah,
Yes, you are.
and I'm answering to the Learn Council is aspect of recording, the aspect of recording taking place, where you see the technology of smart glasses being applied over here. Now, various countries have welcomed this particular glasses as per the fact sheet, and it is approved for sale in the Union of Indus land without any device specific regulation and framework. So over here there are already regulations that are present. Need not be a new regulation that would stipulate or guidelines to be issued by the court to ensure that there should be protection for users. Now, the sale would not have been granted if there wasn't any provisions or protections in place beforehand already. And they are equipped with they are equipped with audio and video recording, real time live streaming, and as the users are aware, there are usage of artificial intelligence, and the recording functionality is activated. Even though they're activated discreetly, they are used in a manner where the users can know that they have recording.
Thank you, sir. Understood. Thank you so much. We'll end with the session. I think we'll end with this round for today.
Uh, just one humble request.
Anji.
Uh, uh, so the both memorial will also be considered, like how our first page was considered, their first page will also be considered.
Because their first page is correct, sir.
I understood that both the cases have to be mentioned separately, one
No, sir.
after another.
Once you mention, I know this is the clubbing of cases. That is Chow versus Giza, then Rathi versus Giza. It is like this, not Chow and bracket PIL petition. That is to be considered. If you by any chance have the memorial of the respondent side, please see their first page. That would be helpful for you to understand.
Just one more clarification. Our memorials were scored separately.
Sorry,
Our memorials were scored separately. That was a separate score for memorial scoring.
I think so. There must be some memorial, but I would consider it. Okay. Thank you, sir. Thank you so much.
Thank you.
All the best.
Thank you. It was a
Thank
pleasure
you.
of
Thank
arguing and
you.
learning from you. Thank you so much.
Same here. Thank you.
Thank you so much,
Thank
everyone.
you,
You
ma'am.
can leave now.
Thank
Thank you,
you.
ma'am.